let's kick this off with a round of introductions, starting with Mr. Turkur, then Brandon, and then Neeral. Kindly introduce yourselves, your firms, your experience, and expertise.
Okay, thank you very much, Abhi. I think you asked us to talk about years of experience. I'll stay away from that one. A little too much to go over. But this is Rohit Tarkar with CSG Law. I'm a partner in the Immigration Group. It is a full-service law firm that's actually headquartered in the state of New Jersey. It's got about 250 attorneys, and we pretty much do everything. We also have a New York City office, and that's where I sit in, although I live in New Jersey just because it's much more convenient. I've been doing EB-5, and I'll just limit myself to EB-5, and not take up Abhi on this overarching offer for about over 11 years. And I've had the pleasure of knowing Abhi, Brandon, and Neeral for that pretty much the full length of time. I do focus mostly on India simply because I'm from India. I'm from Mumbai. I speak 3 languages pretty fluently, and it's always nice to go back home. Thanks, Abhi.
Thanks. Brandon.
Thank you, Abhi. It's going to be difficult to go after Rohit, but I'll do my best. So, Brandon Meyer, founder and principal of Meyer Law Group, with offices in San Francisco, New York, Charlotte, North Carolina, and Guangzhou, China, and Ho Chi Minh City, Vietnam. I've been doing EB-5 since 1998, so 27 years now. In the Bay Area, so we do a lot of we focus quite extensively on the H-1B EB-5 market, and thank you for the delighted to be here with you today.
Thank you for joining. Mm-hmm. And Neeral.
All right. Well, thanks everyone, and thanks Abhi for having us. My name is Neeral Patel. I'm a partner at KLDP. I'm the P in that. And we have offices in New York and California, full service immigration firm. We specialize in EB-5. I've been doing EB-5 for about just a little over 10 years now. Originally born and raised in the UK, family from India, lived in California for a bit, and now settled in New York. But happy to be here.
Amazing. Thank you. And lastly, about myself. So I used to be an EB-5 attorney. I used to be an attorney in India. I practiced in Delhi High Court and Supreme Court. Then I was a partner at an EB-5 law firm in New York. In 2018, I moved to the investment side as a licensed finance professional. And at Golden Gate Global, I serve as the head of global business development. And just by virtue of being of Indian origin, 99% of my clients and investors are also of Indian origin. And a bit about Golden Gate Global. Golden Gate Global has been around since 2011. And we have raised a little over $850 million from about 1,750 investors. But something that we are really proud of is we are one of the handful of regional centers that have repaid more than 550 investors and have hundreds of I-829 approvals. So we are very proud of that track record. Before we get started, I just want a quick disclosure that this webinar is for informational purposes only. And it's the opinion of the speakers. None of it should be construed as legal advice. And if you wish to move forward with your EB-5 petitions, obviously work with licensed professionals. With that, we will kick it off with quickly kick it off with the fundamentals of EB-5, and we'll get into the advanced topics and also talk about the latest gold card and the H-1B 100K fees, et cetera, et cetera. So we will dive into all the hot topics as well. With that, Rohit, if you could shed light on just the basics of EB-5, the investment amount, and so on.
Thanks, Abhi. Okay. So EB-5, EB stands for employment-based. Let's get that out of the way. There's no mystery over there. The EB-5 visa is essentially intended to get you a green card upon creation of jobs. It's not a write me a check, give me a green card story, which some people think it is. It is not the sale of a green card. It always bothers me when people say, oh, the green cards are being sold. They're not being sold. You investors are actually contributing money, creating economic benefits through job creation, and that's how you're getting your green card.
Thank you. So EB-5 is an investor visa, and it requires an investment of $800,000 in targeted employment areas, $1,050,000 in non-TEA or non-targeted employment areas, and the investment should result in creation of 10 new American jobs. That's a very important aspect of EB-5, and the funds that the investors are investing, the source of funds needs to be properly documented. And I'd like to discuss every aspect of that statement now. So, Brandon, I'll first come to you on this. And can you explain to the audience here the investment amount, the investment requirement, and also how the jobs are created in EB-5?
Yeah, so, Congress, the original intent of the EB-5 law from 1990 was to drive EB-5 investment toward rural areas. That as an legislative objective, that pretty much failed. In pre-Reform and Integrity Act, you saw a lot of, hotel projects on West 57th Street in Manhattan and other downtown Los Angeles, not in rural areas. So Congress, when they drafted and enacted the Reform and Integrity Act, said, okay, let's try to address that. So we'll keep the traditional high unemployment TEA designation. That still exists. But now we're going to create this so-called rural set-aside. And we're going to mandate that U.S. immigration process these, people who invest in rural areas much quicker. Spoiler alert, rural investing, USCIS processes rural petitions somewhat faster, but in most cases not appreciably faster. But nevertheless, Reform and Integrity Act is working in driving investment toward rural areas. But, nevertheless, whether it's 800,000 in rural high unemployment or infrastructure or 1,050,000 outside of those, but let's face it, it's like, you're driving down the road, there's two gas stations. One is I'm in California, so, gas is expensive here. So if one gas station is $4 a gallon and the one next to it's $5 a gallon, which one do you stop at? Of course, the one that's $4 a gallon. It's the same concept with EB-5. And for that, I'll just mention before I hand it off to Nero, the two critical pillars of any successful EB-5 are the following. Number one, does the project you select ultimately create the jobs? And number two, can you show whether you're investing 800,000 or 1,050,000? Can you show that that's coming from what we call lawful source of funds? So project that creates jobs, number one, and documenting lawful source of funds, number two. Those are the pillars of any successful EB-5 initiative.
Thanks, Brandon.
And building off of that, and I think maybe Abhi, you might disagree with me here, but I think, it's the source of funds is what it really comes down to. I think when you're working with a quality project that has a good track record, that we know is already under construction, fully financed, it has all these things in place that each of us have seen be successful, it gets kind of easy to pick a project. But it's always the source of funds, like you said, is what arguably takes the most amount of time. And right now, I think we see lots of issues pop up, especially with people trying to gather their funds, as lawyers, as practitioners, us trying to track each and every. It feels like we shouldn't have to track each and every dollar, but we find ourselves tracking each and every dollar of that 800,000. And so it's important to work with your attorneys, identify your funding sources, your strategies, and finding the best path forward where you can document that $800,000 the best.
Great. Thanks for that. Now, coming to Rohit, could you shed some light on job creation, the 10 new American jobs I was talking about? How are they calculated? And I guess you'll also have to go into the two ways of getting the EB-5 visa.
Absolutely. Thank you, Abhi. Okay. So let's get the easy one out of the way. What we call direct employment or direct jobs, which may well be in a DEA. But if you're going down a direct investment, I think there are two things that are very important to remember, one of which was changed dramatically by the RIA of 2022. You're allowed only one investor in the direct project. If you have more than one investor in a direct project, you pretty much have no choice but to go through a regional center. So if you're doing a direct investment, while a lot of people, especially in particular communities in India India prefer the direct investment because they're entrepreneurial by culture, they're entrepreneurial by nature, and they prefer to take their own risk with their money because the rewards on those returns can be pretty substantial as well. But they've got to then deal with direct job creation, meaning direct from a US perspective, direct employees, direct W-2s. It's not going to be a 1099 person that's going to qualify for your EB-5 direct employment. So that can be very, very challenging. And I think we have traditionally seen a very small percentage of investors go down that route, and probably an even smaller percentage being successful in that option. However, that does exist. There's no question about that. The second, which is much more common, has traditionally worked very well for all our investors, and I think I speak on behalf of all of us, would be the regional centers, because the regional centers do not need to have W-2 employees. Their job creation, which very often can be done even before the investor comes into the picture, which is always great. Their job creation is based on economic modeling, those studies created by an economist, where they are factoring in labor department statistics. They are factoring 3 different kinds of jobs in there: the direct jobs, the indirect jobs, which are created by suppliers to the people who are building the projects, and then you have the induced jobs, which are also created by the spend from all the earnings of all the different people. So that job creation is super important, and that is the reason why I'm sure our audience hears, whether it's directly from you, Abhi, or your competition, or from the attorney saying, oh, they've got 50 jobs per investor, and everybody's scratching their head and like, where the hell is this number coming from? But the common perspective is, yes, it's real, because it's not an exact W-2 employee, it's not a head count. And you've also got to remember that these things are economic models accepted by the immigration, job creation being either very underway or completed before the investor comes in, also completely accepted and very successfully done over the years. So job creation is one of the biggest advantages of investing in a regional center.
Yeah, and if I can add on to Rohit here, as I have consultations, and I'm sure this is true for everyone on this call, and you have consultations with potential clients looking at EB-5, the big concern is, well, what if, 4, 5, 6 years from now, whenever it's time for me to file removal of conditions, the project has failed, the project hasn't created the jobs. And my answer is, you should never get to the I-829 stage and be concerned about whether or not the jobs have been created. That should never be a surprise. We should know in my opinion, within the first year of investment, if not sooner, based upon the pre-existing construction spend and the overall construction progress of the project, whether or not the jobs have been created. And I mean, Abhi, as you talk to potential investors and in your projects, I'm sure you always mention, to date, we've spent X amount, the project spent X amount of construction, and that's created Y number of jobs divided by 10. This number of investors have already satisfied their job creation requirements. And, the good thing about the Reform and Integrity Act, prior Reform and Integrity Act, if someone invested in a quote unquote failed project, they were pretty much stuck unless they wanted to start over again, new priority date, new investment, everything. The Reform and Integrity Act created a mechanism for investors to pivot to a new project if their initial project isn't quite meeting its metrics. It's not a perfect process. It's still evolving. Yeah, but it does exist, and we've had to use it, unfortunately, more times than we would have preferred for some of our clients.
I have a few follow-up questions on this. So, as the law in the direct project, which is if someone starts their own business, they need 10 new American jobs, and they need full-time jobs. So, one, what is a full-time job under the EB-5 laws? And the second question, and Neeral, both are for you. In case of a regional center project, we are allowed to have 90% indirect or induced jobs and 10% direct. Does the probability of approval go up if we have only 50% direct and 50% indirect and 50% direct, or it doesn't really matter? So both questions are for you.
Yeah, I think with the direct, I mean, I think it's 35 hours a week is what makes a full-time job, and you can use two part-time positions to make up a full-time job as well. It's also important to know that it's not jobs, it's actually positions. It's the positions that have to be created. So theoretically, at the time of filing the 829, you don't have to show that you have 10 people employed on payroll at the time of filing. You have to show that you've at least created those 10 positions as a result of this investment. And you've also, of course, done your best to fill these positions as well. Mm-hmm. And then in terms of the regional center, I think, I think the job creation has actually gotten better. So I think, it's become a lot easier to meet those job creation numbers, especially for the regional centers. And I think what you're seeing with these quality projects, you're seeing these massive buffers as well in terms of job creation. So, and it's like Brandon said, this really shouldn't happen. I do think the 829 is probably the easiest part of this entire process. But if you do run into an issue where, a project has become delayed or a standstill or whatever, then that job creation buffer certainly does help, provided that, of course, they've met certain metrics in their construction milestones.
Right. Now, we also briefly touched upon Reform and Integrity Act. So for context, EB-5 has been around since the 90s, and the Regional Center program was a pilot program for the longest time. And in 2022, the EB-5 Reform and Integrity Act was passed. So I guess, Rohit, could you shed some light? What were like some of the changes that were introduced by the Reform and Integrity Act, which also, what was the impact of that on the demand of EB-5?
Thank you, Abhi, again. The demand for EB-5 has just skyrocketed. I think that is fantastic. It's very comforting for all of us who are in the business because it validates the program. It validates the EB-5 visa category as well. One of the biggest changes was referred to earlier by one of our panelists, which gave you the ability to file a concurrent adjustment of status. And like Neeral said, that it allowed you to get an EAD, allowed you to get advanced parole, allowed you to remain in the United States. And like Brandon correctly said, it not just allows you to remain, the way I explain it is, it entitles you to remain in the United States. Yeah, there are going to be some conditions that you need to comply with. Don't leave the United States if you're on an F1 till you have an advanced parole. And, I'll let Abhi, you deal with that question a little bit down the road. But clearly, that's a huge change. The amount has been solidified at $800,000, which will go up as of Jan 2027 because it's supposed to get changed every 5 years. I think it's done a lot of good for the investors because there is a third-party fund administrator that's been introduced that protects them or gives them a much greater degree of comfort, saying there are less likely to be bad actors and bad players and misuse of monies that are invested. There is, a mandatory, not just the fund administrator, but an audit probably that's going to take place. The amounts, it has certainly weeded out a lot of regional centers. For lack of a better word, I'm going to say the marginal regional centers have stepped out of the way because either they couldn't raise the funds, they couldn't compete with the big boys like Golden Gate, they couldn't necessarily keep up that pace over there. So those are at least some of the highlighted changes. From an investor's point of view, I think the biggest change, the absolute most pleasant surprise, or the windfall, if you want to call it that way, is filing the concurrent adjustment of status. There are several other changes which may not impact the investor that much, though.
I couldn't agree more. And Brandon, I'm coming to you with this now. Okay. Could you shed some light on the grandfathering clause, which I feel, in the light of the program expiring in September of 2026, and other protections for the EB-5 investors?
Yeah, so there's always been this fear out there that if I'm an EB-5 investor and I invest today, that U.S. immigration could change the rules on me tomorrow, and that would adversely impact my EB-5 process. And so, in order to address that, Congress put a provision in the Reform and Integrity Act to say, okay, if you move forward with your EB-5 and file it prior to September 30th, 2026, if U.S. immigration tries to change the rules in the future, you're exempt from those rule changes. So basically, if you invest and file prior to, basically, this time next year, then you're exempt from future rule changes if USCIS were to attempt something like that. So it provides. I'll take a little bit of a contrarian view. I don't think grandfathering is everything, but it is at least an attempt again by Congress to provide some reassurance to EB-5 investors that the U.S. government is going to process them in a fair and even-handed manner going forward. So, the Reform Integrity Act, for the reasons that Rohit mentioned and this grandfathering, is so much more investor friendly than what came before it. It's also so much less regional center friendly for some of the reasons that Rohit mentioned. I mean, basically, if nothing else, it significantly increased regional centers' compliance requirements and compliance costs, which drove some of the kind of, I think Rohit used a very, very kind word when you said marginal, but it drove some of the marginal players out there like, do we want to do this if we have to pay $48,000 plus every time we do a new project and all these other year-end compliance costs? We're out. And so that's had the positive effect by leaving those who are still in the business on average are, far stronger and far better than what we saw on average 5 years ago in the market.
And if I could just add to that, I think all of us have our own issues with USCIS as an industry and as a whole, right? But also credit where credit's due. I think as a result of the Reform and Integrity Act, USCIS has improved the EB-5 program. I think processing times have gone a lot better. Again, a lot of these more investor-friendly provisions such as grandfathering, the concurrent filings. I mean, I think, we're seeing APEADs issued in less than 6 months. We're seeing I-526Es processed in less than 12 months. So, they have improved greatly as a result of that RAA.
Yep. And Neeral, since we are on that topic, can you also shed light on the bad actor provision introduced by RIA and also can the executive action of the president impact EB-5 in any way or change the laws in any way?
Yeah, so I'll actually answer your second question first, just because it's a little bit shorter. So, we're not going to see any changes to EB-5 through an executive order. I mean, this was a law that was enacted by Congress, and only Congress can repeal this law. And it's not something that I would expect anytime soon. I don't think any of us would expect this anytime soon. I mean, we have to remember that this brings so much economic development, job creation, and free money at no cost to the U.S., to these Congress people's districts, and to their people. And then in terms of the bad actor provision, again, I think the RAA was centered around protecting investors against some of these more marginal regional centers, right? And right. So if there is fraud or misrepresentation now, these investors are protected. They're able to pivot to a new project, retain their priority date, and continue going with the process, which otherwise wasn't there before.
I have something to just add on, pivoting off what Neeral just said. I think we all recognize clearly that the president is a businessman at heart. There's no two ways about that. I think money coming in is never going to get turned away by him. I think for those of us in the industry, I think we also know that clearly there are people close to his orbit who do use the EB-5 and do raise monies in the EB-5 and I'm sure that they have some communications with say, hey, this is how much we're raising. This is how much we're getting. That's another reason why I don't think EB-5 is going to go anywhere away. I think it's here to stay. And I think most people have found very good use for it. And therefore, it's going to be there.
I agree with that. And also, I guess the next 1 year will be interesting because the program is due to lapse in September 30th, 2026, which will obviously spike demand. And also there is so much political storm everywhere about the immigrant community. But also the other thing is that there is a provision of increasing the investment amount every 5 years at the rate of the inflation rate. So we can expect EB-5 around January of 27 to cost like maybe $900,000, right? Like if you take into account cumulative thing. Any thoughts on that?
Oh, I think somebody recently in Miami, just a couple of weeks ago, threw out the figure of about $937,000
Right.
as of January.
So now moving on to the specifics of EB-5, and this term 956F approval or exemplar approval is thrown around a lot. And I guess, Neeral, I'll come back to you on this. What does it mean to have an I-956F approval? And does it guarantee EB-5 success in terms of a green card, job creation, repayment of capital?
Yeah, those are great questions. And I think, pre-March 2022, projects had the option of applying for an exemplar, which is, in other words, the 956F approval, basically a stamp of approval by the government. Post-March 2022, USCIS or Congress made it mandatory that every project must receive a 956F approval in order for an EB-5 petition to be approved under it and subsequently a green card to be issued thereafter. Now, that doesn't mean you need 956F approval to necessarily apply. So a project can apply for 956F approval as long as it's been pending for 10 days, then EB-5 petitioners can start filing their individual petitions under that project. It's a good question that you asked, like, does it guarantee success? Short words, it doesn't guarantee success. It does give a lot of comfort in the sense that all the information that an investor is receiving or should be receiving, all the documentation they're receiving has already been sent to the government for their review. And basically they're approving that, okay, this job creation methodology is correct. This project is viable from a financing perspective, from an immigration perspective. If everything in this business plan plays out, then yes, you should get through the immigration process successfully. At the end of the day, of course, we know that these are still developments. Forget about EB-5 for a second. These are still developments that have to deal with real market conditions, whether it's tariffs, previously it was COVID, or the 2008 crash, or whatever it might be. There are still real market conditions that projects need to account for. So, I always tell investors that, look, if you're working with a reputable regional center, the 956F, you should be getting it approved, but also ask them about their prior deals. How have they filed their 956F before? Look at the current deal. Does this asset meet all the requirements that you need to get comfortable from a capital protection perspective and a green card perspective, and you proceed according to that?
Great. A follow-up to all of this is, again, Neeral, you mentioned that even if I-956 is pending and not approved, investors can still file their I-526E or application for a conditional green card. Are they also eligible for the interim benefits, AOS, EAD, AP?
Yes, absolutely.
Can you explain those terms? Sorry, I just use that.
Absolutely. So, whenever we're doing this, if you're inside the US and you're filing concurrently, you're filing 4 petitions at once. The EB-5 petition is the I-526E. The conditional green card is your 485, travel permit I-131, and work permit 765. You're applying for all 4 at the same time. And then everything generally happens in a linear fashion, and you're still able to do that without 956F approval. So you submit all this, and you more often than not, you're probably going to get your AP EAD before 956F approval and then before your EB-5 petition anyways. But absolutely you can.
Got it. And going back to Rohit's point back right at the start of this webinar, that it is not first in, first out. And we have experienced it firsthand that we filed an I-956F exemplar for a rural project in 2023, May of 2023. And then we filed a 956F exemplar in January of 24 for our second rural project. The second exemplar approval came before the first one. It was the bizarrest experience ever. And in our second project, we have more I-526E approvals than the first one. The rest are pending. So clearly it's not first in, first out. the adjudication trend is not consistent at all. With that, let's talk about what are regional centers and what do they do? And Brandon, I'll come to you for this.
Yeah, a regional center is basically a fancy term for a group that goes to U.S. immigration and asks for a non-exclusive license to develop EB-5 business projects and raise EB-5 capital in a limited geographic area. And in exchange for that license is subject to the ever increasing stringent compliance requirements that U.S. Congress enacted in the Reform and Integrity Act and asked USCIS to administer on their behalf. So it's basically just a license. And so you have some groups, such as Golden Gate Global, for example, that have that license to work with third-party developers to develop EB-5 projects. Other groups, developers own and operate their own regional centers to raise money for their own projects. Those are basically the two submodels of EB-5 regional centers.
Got it.
But all are approved by USCIS before. Whereas in the 956F, you can start onboarding EB-5 investors prior to approval. However, a regional center cannot do EB-5 business until it's approved by USCIS.
Right.
Yeah, if I may just add to what Brandon just said, I think it's important because I'm asked this question many times. Is the regional center and their activities underwritten by the U.S. government? And does that guarantee me anything? And it just want to clarify, it's not. It's just a private company that's out there doing business. It's like any other license that you get from the government with incorporation, etc. That's important, I think.
Absolutely. When I used to practice as an attorney, I used to say it's like a driver's license. It doesn't tell you how good or bad I am. It just tells you I'm licensed to drive. So with that, we'll dive into source of funds. So Rohit, source of funds or funding in general is a very important step of investment immigration, right? That's what it's built around. So the investment amount of $800K, I'll stick to $800K because that's all the projects ask for today. There are next to none 1,050,000 projects. So when is the funding requirement, and do all the funds need to be invested right away from the start, or it can be done in stages?
Thanks, Abhi. Okay. So I'll begin by saying that in my opinion, there are three amounts of money that you need to prove the source of funds. And I know Brandon referred to this earlier. Source of funds is the single most important piece of your EB-5 activity, presuming that you're going to be investing in a credible, well-established regional center like Golden Gate Global. You have a 956F approved, like Neeral referred to it earlier. The immigration is now not going to worry about that as long as you're following the business plan. So you're back again focused on your source of funds. Three amounts that need to get established as the source of funds. One is your $800,000 investment. Two is the admin or the management fee that's negotiated between the investor and the regional center. Three is the filing fee for the 526E, which is $12,160. So those three amounts, I tell people, you got to document as source of funds, which means you got to prove that they're lawful. The word lawful doesn't mean it suffices if it comes from a bank account. You got to be able to trace it back to its origin and how did it develop till you actually used the money for EB-5, where it comes into the investor's account most times, and then goes from that account to the regional center's escrow account under the regional center's guidelines. So the source of funds is, and I think Neeral and Brandon both referred to it earlier, takes the longest amount of time to do. According to me, it's easily a 1 to 3 month process, depending on how complicated the process is, depending on how quickly one can obtain the documents. And I know, like Neeral said, we find ourselves needing to document every single penny. Yes, there was a decision last year, which I think from a different law firm, which basically said you can look at where the money is coming from apart, but that's much more of a last resort strategy as opposed to a first resort. That's not your best strategy, because although you have to deal with preponderance of the evidence, which only means it's more than likely that it's approvable, the immigration officers are looking for every single penny. So if you're not going to be able to do that, then you better expect an RFE, which I think most people don't like to get because it just digs deeper and delves deeper into the source of funds, and you're opening up a can of worms. So source of funds, you got to work with your attorney very closely on it. Do not feel that the attorney is out there it's not a gotcha by the immigration attorney. It is trying to do their best for you for the source of funds to document it. And I've certainly had clients who've said, look, my accountants drive me crazy. You're not even an accountant. What are you doing to me? And that's fine. At the end of the day, when we get an approval without an RFE, there's usually a smile and a big thank you. And I think that effort is worth putting in right from the beginning. So source of funds, single most important thing. Work closely with your attorney on this. Don't feel they're out there to get you or to give you a hard time. That's what I would say. I mean, and of course, you got to comply with source of funds for the country from where you're getting the monies as well. Needless to say, I know that, Brandon deals with a lot of investors from other countries. I deal pretty much primarily from India. So compliance with Indian tax regulations, the Reserve Bank of India, LRS rules, all of those things must be taken into account. And I, as a US attorney, do not give advice on Indian law. I can connect them with lawyers in India who can guide them, but I think that's very important for investors to remember and to keep in mind.
I kind of agree with that. And what we as an industry see is that when I have a call with EB-5 investors, I can briefly talk about source of funds, but I always mention I can't represent them. And everyone is surprised to learn that it takes minimum of 4 weeks, can take up to 12 weeks to document source of funds. And here they are talking about a project and investing in it. And I'm like, the first step is retain an attorney. Start the work on the source of funds, because if it's complicated, this project may not even be available by the time you're done with that. Most people think, hey, we have a grasp of our source of funds, and they're shocked when they start working on it, on how tedious it is. So with that, Neeral, I'll come to you. And in terms of setting expectations, right? How far back do we need to go to document source of funds, like really into the bank account statements, tax returns, et cetera? Let's take an example of a real estate sale in that case.
Yeah. So typically, anytime you're using an asset like real estate or even your stock portfolio, you need to document how you acquired that asset in the first place. So for real estate, you'll have a down payment and then you'll have financed the rest through a lender, through a mortgage. So you need to be able to document how you acquired the down payment and even the mortgage payment schedules. We're seeing requests from USCIS to document exactly how and when you earn the funds to make those mortgage payments as well. Now, I think everyone, even USCIS, understands that documentation more than 7 years ago. A lot of finance companies, banks do not keep those on hand. So you can supplement certain things through secondary evidence like an affidavit, declarations, and things like that. But you need to give your attorney a complete understanding of your source of funds in order for us to strategize the best way forward. I think one of the more common things I've seen pop up, I don't know about you guys, but it's Zelle transactions. We're seeing USCIS really come after, these US bank accounts. And if they see like a ton of Zelle transactions, they want to make sure that these are accounted for, because, you're in your bank account, it's like a bucket of water. These funds are commingled. So even if you're saying it's W-2 income, if after that you receive some payments from some friends for whatever reason, you may have to go in and explain that. So, and that's kind of what's adding to the time it takes to prepare the source of funds. They weren't as strict about this as before, but I think recently they have become a little stricter on these topics.
And not only Zelle, but crypto as well, because U.S. immigration's a bureaucracy. They're used to doing things a certain way. So when, I always kind of say on the project side, there's no bonus points for creativity in EB-5, only the creation of avoidable headaches. And you extend that to new concepts such as Zelle and crypto. And then if they haven't seen it before, their natural inclination is to, not approach it initially from a positive perspective. And so, so if you're funding your source of funds through crypto or Zelle or some of these newer kind of financial platforms, be prepared to have to explain it significantly more detail than if you were just selling your, RSUs from your company, which are pretty straightforward.
Yeah,
And it goes back to Rohit's point. Oh,
yes,
carry on.
sorry, I was going to jump in because there was a question that came up on screen, which I did not answer, whether you need to invest the 800K all in one shot. Well, the law does provide that you're allowed to be in the process of investing. However, despite that, I think most regional centers will want the monies within a reasonable amount of time. You might give them 3 to 4 months, but if somebody says, I want a year to pay out, I don't think that's likely. I don't think that's going to happen, simply because of a very simple business reasoning. Golden Gate has people waiting to get into their projects. Why would Golden Gate wait to receive monies over a 6-month or a 9-month period of time from somebody if Brandon or Neeral or Rohit can give you that check today? It's just practical. It's not going to happen. So legally, it may be allowed. Practically speaking, I don't think that basically that's going to work. For investors from India, it can often work quite well if you're giving part of it in December, January, and then you're giving the balance in April, simply because you're kind of using the two Indian financial years, and most regional centers understand that without a doubt. But I think it's a question of what is the period of time that you're looking for, and very importantly, you have to be able to identify your source of funds in the beginning. You can't then go out and change your mind and say, oops, you know what, the house that I was going to sell burned down, so now I'm going to borrow money from a bank. That's just not going to work. You're asking for trouble. So I think a lot of I shouldn't say the younger generation, but compared to me, pretty much everybody's the younger generation who says, oh, I'm going to get my bonus later on. And suddenly, unfortunately, they might find instead of getting a bonus, they got a pink sheet. May not work well for EB-5. And clearly, I would also expect that a regional center like Golden Gate wants to minimize that risk, as opposed, even if you can't eliminate it completely.
Yeah, so I'll add a few things to that. Sorry, Neeral, just from a regional center perspective, I'd like to add a few things to that. It also depends on the size of the project and capital needs. So the one thing is, yes, it is absolutely okay to invest partially, file your I-526, lock in your priority date. You can start with 150 or 200K. That's perfectly fine. Now, considerations are, if it's a smaller project and has capital needs starting from January of next year, a regional center cannot give 6 months time frame to fund in full because the developer needs the money sooner, right? So that's one consideration. For a larger projects that we've done in the past where we were raising capital over a year, 6 months was absolutely fine. The second consideration is, in a lot of cases when we did give 6 months to fund in full, for some of the investors, a good thing turned into bad. Their petition got picked up in 4 months. Mm-hmm. And instead of getting an approval, they got an RFE to prove whether they're funded in full. Now, if you're waiting for an event such as sale of property, RSU vesting, et cetera, well, you don't have that luxury anymore. You have to invest then and provide proof that you funded in full or you get a denial. As a result, it increase the economic burden on the investor because they had no choice but to withdraw their petition, wait for that event to happen, and refile instead of suffering a denial. So that adds the added USCIS fees, which used to be $3,500 and is now $12,500, right? So that's a lot of burden. So these are some of the considerations when you're looking into a project you want to partially fund. It's fine, but be aware that it can cause some heartache along the way.
Yeah, no, interesting, Avi. I don't know if Rohit or Neeral, you've seen this, but, Avi, we just had a case, and the gentleman is actually on the call today, so I'll say hello to him, where his 526 was approved, I think Tuesday or Wednesday, but he still hasn't fully funded. No RFE, no NOID, no request for consideration. So I don't know if that's a trend. Hopefully that is. First time I've seen them approve a 526 without RFE or NOID, where the individual hasn't fully funded at the time of adjudication. So knock on wood that we'll see more of those. But yeah, generally speaking, to your point, you want to try to fully fund sooner rather than later because, so like the other gentleman or other people out there that, where their case was picked up before they fully funded, and now they've lost control of their funding timeline. So
Right. And Neeral, sorry, I cut you off early on, but please.
No, I was actually going to I was just going to echo exactly what you said is that, at the end of the day, these projects can give you as much time as you want to fund. But if USCIS comes knocking, then you have to be prepared either in 30 or 90 days to not just fully fund, but then also provide adequate source of funds documentation for that. And that, if source of funds already takes 4 to 8 weeks or so, that can get a little dicey.
Right. And also, like, even if you fund partially, right, you are eligible for those interim benefits. All the investors that invested with us with a 6-month horizon, they got their EADs, APs, no problem. There was no RFE on that. It's just that you're risking an RFE for if there is a faster I-526E or conditional green card adjudication. And Brandon, you're right. We had a few approvals like that too, with only partially
your APAD is not tied to your funding per se. So you don't actually need to be fully funded to get your APAD. So you can get started earlier to get that process started.
Right. So now coming to the topic of rural and high unemployment, right? My favorite topic, not. But Neeral, what are your thoughts on retrogression? What do the numbers look like, rural versus HUA? And I mean, let's start with the basics. What does retrogression mean?
Yeah, so retrogression is basically a visa backlog. The entire immigration system is built on demand and supply. There's a limited number of visas available, and when demand exceeds that supply, then you start having these backlogs, otherwise known as priority date cutoffs, otherwise known as retrogression. We see it in all the other categories, EB1, 2, 3, and EB-5 is no different, right? We see it for India and China under the unreserved. Under the reserved, it's obviously current right now, which allows you to apply for the APEAD. But, my number one, my advice to a lot of clients who come to me and they ask me this question, when is this going to retrogress? I'm like, if I knew that, I'd go buy a lottery ticket and probably quit my job. It's like no one knows exactly when retrogression is going to hit. And then on top of that, no one truly knows how long it's going to hit. I think when this program or when the RAA first came online and the first applicants went in, I think July or August 2022, there were only high unemployment projects. So everyone flocked to high unemployment. Then you started seeing rural projects, you started seeing quicker processing times, everyone flocked to rural. And so we all thought high unemployment retrogress first. Now people are saying potentially rural retrogresses first. All that's to say is no one truly knows. And I think you sort of make peace with that unknown and understand that, if you've made a decision to do this and you have the financial means to do it, you definitely do it sooner rather than later. You lock in that APEAD. And I don't want people to underestimate the value of that APEAD because 9 out of 10 times it's good for 5 years. You get on a combo card and that gives you that stability to wait out any sort of potential retrogression.
And not only the EAD AP, but ongoing legal status in the United States for the duration of the process. Let's recognize reality here. The news that came out around last Friday about the $100,000 H-1B fee that then the administration spent the next 3-4 days walking back and saying, no, it's really something different. And then this, the H-1B cap, proposed H-1B cap process. Make no mistake, this administration is coming after the H-1B program, no doubt. They are trying to figure out ways to essentially kill it, no mistake. And one of the things we've learned from the first time these guys were around, let's take the travel ban. It took them 3 attempts before they figured out a workable, viable, legal travel ban. They're going to do the same thing with the H-1B program. They're going to figure out, they're going to try this, they're going to try that. It's going to be a trial and error approach. Courts are not coming back. Eventually, they'll figure out a way to fundamentally kill H-1B. That's their goal. They've been clear about it. And also, if there's any F1 students on the call, guess what? OPT's next. Actually, is probably going to come first. So again, if you have the means to do this, the data points are clear. Reality is staring you in the face. If you want to be here in 5 years, I mean, as valuable as you are to your companies are not going to be paying $100,000 for you to stay here. They're just simply not. H-1B, and given the Reform and Integrity Act, given how USCIS is currently handling EB-5s, given currently no retrogression, the time is now to do EB-5 because it may not be here forever. And it's simple as that.
And think about it this way, right? I think one of the bigger driver of demand happened maybe a year or so ago when we saw all the tech layoffs.
Right.
And everyone knows if you're on H-1B and you're laid off, you got 60 days to either find a new job, a new H-1B sponsor, or you got to leave. And that's when a lot of people really started looking into EB-5 because, like Brandon says, the legal status, filing that 485 at least allows you to stay in the US. If you've got a family, you can kind of continue as you would until you get that APAD. You can start traveling and working again, but it allows you to stay in the country, which is, you can't underestimate that.
A couple of thoughts about retrogression in general with EB-5, right? Back in 2018, there was this noise about there will be 6-7 year retrogression for Indian-born investors. No one has ever been able to predict it for one big reason. EB-5, unlike every other employment-based category, does not have a standard processing time. Retrogression is not based on the number of applications filed, but the number of applications approved. Since we do not have certainty in terms of timeline for approval, and there is no premium processing, so that, again, as a result of that, and not to mention it is also not first in, first out, there are so many moving parts that it's impossible to predict when retrogression will hit. And when it hits, it is impossible to predict how long it'll be for because we don't know how many applications have been approved. So it's the sad truth of this industry that you really cannot plan around it. All you know is there is uncertainty around non-immigrant visas, and the one visa that gives you certainty, you don't know how long it'll take to get it.
Yeah, that's so very, very true. And in fact, I think just to weave that into the selection of the projects, or at least some kind of guidance, which I, as an attorney, do not give because I do not have an SEC or a FINRA license, at least. But I do tell them to think about the quality of the project. And, we've talked about the quality of the project. We've kind of referred to the return of capital. But I think it's important not just to look at the job creation, but also the return of capital possibilities. And that's a whole different conversation. And that may come into play when also, whether you're in the US or outside the US, when you're selecting the project and you're trying to decide whether you want to go in for a rural project or you want to go in for a high unemployment project. And I think I'm not wrong if I say that since the program has been around, there's a lot of track record of high unemployment projects returning monies, maybe less so for rural. And my gut says that the rural projects are more than likely to start returning monies somewhere around 2027, somewhere around that 5-year timeline. And that will then give them a greater edge, I think, also in terms of saying, here's our track record, which competes well with the HUA or the high unemployment area possibilities as well. But it's impossible to predict. There's just no way to do it. I think even Charlie Oppenheim, who used to head the visa division for years, has been consistently proven wrong with the visa bulletins, despite his so many years of experience and being supposedly able to predict what's going to happen down the road.
Yeah, I also think I have this formula because there's individuals and groups out there that publish these blogs or these webinars and say, oh, it's going to be 5-year wait, 7-year wait, 12-year wait. To Abhi's point, no one knows, but here's the fundamental flaw with that with the analysis that these people put out. It's not taking into account what I call the 4 Ds: denial, death, divorce, dropouts. So all these analyses assume.
What about marriage? You just dropped the 4 Ds.
Yeah, or marriage. I mean, I've had some people do that. Halfway through EB-5, they're like, "Yeah, I'm going to get married instead." Okay, great. That's a dropout. And so, all these analyses assume that 100% of the people that are entering the system will complete the process. We know that's not true. People get denied at the 526 stage. For example, USCIS is going back and issuing notices of intent to revoke for approved 526s for China cases for national security reasons. People fail for source of funds. even if people have 526s approved, they get denied at the consulate for various reasons as well. Historically, you can probably weed out 20 to 25% of people through either 526 and or consular and I-45 denials. Also, unfortunately, people do die during the process. I've had it, Rohit's had it, I'm sure Nero's had it as well. It happens. People drop out, their needs change. They decide they don't want to do EB-5, or they get married and go marriage-based route. And divorces happen too. And then, one thing that, you mentioned Charlie Oppenheim was traditionally kind of incorrect with a lot of his assumptions. One of his assumptions that he admitted was wrong, but people still use because we're dealing with imperfect information, is the visa multiple that goes into these analyses as well. So long story short, anyone who comes out and says with definitively it's going to be, and they're also not baking in processing times as well to their wait time. I mean, they're assuming it just gets approved instantly. So no, it takes time, whatever that time is. So long story short, if someone gives you a definitive, it's going to be X period, immediately discount it by 30% and then start working down from there.
Also, I mean, the chronic problem with this industry is issuing self-serving statements. If a provider has a rural project, then rural is the best thing. And then when you have a high unemployment, high unemployment is the best thing, right? So take it with a pinch of salt, everyone's selling. So that, again, like we mentioned, there are so many moving parts. It is impossible to predict when retrogression will hit and how long it'll be for.
But it's the most perfect. Sorry, go ahead.
I will say that, they've made this program more investor friendly. That retrogression now is easier to digest than it was before, especially in terms of, the sustainment period, the concurrent filing. You still have these other benefits where you're able to move on with your life without being sort of married to the program for such a crazy long time, if and when retrogression does hit. So I think, that's another way to also look at it.
Yeah, and
building off exactly what he said, it's the most perfect situation in an even more imperfect situation. Your EB-5 is still going to be your ticket, and EB-5 is still there to exist despite certain executive orders or proclamations from the White House.
Yeah, and even if there is retrogression that adds 5 years to it or whatever, I mean, I don't want to, say quote unquote, so what, but like it's still, I mean, you have, as long as you have your EAD and your legal status and your AP, 5 years is still going to be faster than EB2, your existing EB2, EB3, and possibly even EB1 as well. So it's just unfortunately the reality.
So Nero, I'll come to you with a question. So we'll deal with some source of funds issue in a bit, but you touched upon sustainment period. I would love for you to shed light on it. What is sustainment period and how it came about? Because it was not in the Reform and Integrity Act. I mean, it is, but it's ambiguous.
It is, but it isn't.
It is, but it isn't.
Yeah, I mean, sustainment period just refers to the time that you have to be, invested into the project before you're eligible for repayment. Pre-March 2022, your sustainment period coincided with your conditional residency period, which meant that you were eligible, any EB-5 investor in any project, they were eligible for repayment at the end of the 2 years of conditional residency period when they filed their 829. Of course, you still have to come to terms with the project loan terms and things like that, but that was the earliest that anyone could be repaid. So if there was retrogression and it impacted how long it took to get your conditional green card, you add 2 years after that, and that's when you're eligible for repayment, obviously at issue with redeployment and things like that. In October 2023, USCIS randomly posts on their website, hey, actually, the sustainment period is a minimum of 2 years, and as long as job creation has been met, you're eligible for repayment, which obviously is great for investors. And I think it's good for the industry to decouple the repayment from your immigration timeline. So if and when there is retrogression and it takes, let's say, 5 years or 6 years to get in the conditional green card, another 2 years before you can file the 829, you're not waiting that entire time for repayment. Now, when a project says that, they show you their exit strategy and they say, well, we can reasonably expect to repay you in 4 years or 5 years, that's at least more predictable in terms of when you can get your capital back.
Yeah, we really like the new definition because it also takes away the burden of pre-deployment, looking for a project. What if the current developer doesn't want to keep our money for longer? So it does help a lot with that. And it's comfortable for the investors too, right? I feel the way China just collapsed as an EB-5 market in 2016, 2015, 2016, I don't think that's going to happen again. The reason for the
Right.
collapse was not the delay in issuance of a green card, but because it was also delayed the repayment of capital. So I personally welcome this change, and it's great that it's decoupled from the immigration process. I guess coming back to the source of funds topic, one of the hottest topics in source of funds. Sorry, Rohit, please go ahead.
Just wanted to add a little more color to what Niraj said on, that whole issue. I still think that it's not a settled issue as to when the money is to be paid back. And obviously we know that because there are lawsuits out there as well. And I tell my clients, look, we do have some uncertainty on the issue of what is a sustainment period. The immigration has kind of left it open out there, and people talk about money coming back in 2 years. People forget the part that Niraj just brought up. Job creation needs to be completed as well. It's not just saying it's been there for 2 years. That can have its own issue. Regional centers may have challenges with stabilizing the project before they can actually return the monies. And at the end of the day, I don't think an investor is going to complain if they get the money back sooner. But if they at least know that it could be out there for 5 years or so, I think they're mentally prepared. And Abhi, like you said, it's meeting their expectations. I'm more inclined to be conservative and say, look, expect to not getting it back for 5 years, because I'm sure the PPMs, I'm sure all the documents say subject to immigration issues at a later point in time. Because if they go in and say, I'm getting it back in 2 years, and now it takes them 4 years, they're probably going to come back to the immigration attorney and say, hey, you also told me I'm getting it back in 2 years. And it doesn't necessarily fall into place that easily. It's not such a perfect world as we all recognize. So I think it's important to keep a practical outlook on this entire return of money situation.
Absolutely. And from a regional center perspective, I'd like to add here, it is next to impossible to repay capital in 2 years, because to count direct jobs, you need to have 2 years of construction. Now, when a project is constructed, it needs time to stabilize. And till date, 100% of our repayments, right, over 500 investors, they've all been repaid by refinance of the EB-5 loan with traditional bank loan. For that to happen, the asset needs to be complete. It takes a couple of years to stabilize. That's when the borrower refinances the EB-5 loan and repays the debt. So anyways, it's at the minimum 3 to 4 year timeline for refinancing and repaying capital. 5 years gives them enough buffer. So the reality is, what the new sustainment definition has done is that we can repay our investors at the end of that loan term. So we have that certainty, not at the end of 2 years, but definitely at the end of our loan term. So
yeah, it just adds so much more predictability. And I think that's what's key to all these investors, I think, is understanding when am I actually eligible for repayment, as opposed to relying on processes that are completely out of their control, like retrogression.
correct, absolutely. So now coming to the topic of source of funds and loans, and Brandon, I'll first come to you. Can investors, first of all, can they use money that they've earned in the United States or loans against assets in the United States?
Yeah, the answer to both questions is yes, they can.
Great. Now, in terms of loans, is it only that they can use secured loans, or unsecured loans are also allowed?
Unsecured loans are also allowed. There was I think this court decision maybe 5-6 years ago. Chang, don't quote me on that, but basically it allowed investors to use unsecured loans toward lawful source of funds. Now, keep in mind,
Brandon's right, matter of Zhang.
all right. Now, but keep in mind, just because something's legally permissible doesn't mean that USCIS ultimately likes it, especially when they lose in court over the issue. So while unsecured loans are permissible, expect USCIS to examine the loan agreement very, very thoroughly and ask questions if they deem necessary.
Got it. And do these loans have to be from a licensed financial institution, or can they be from individuals, friends, or family?
Yeah, I mean, my personal opinion is that, if what people do in, private transactions is up to them, but don't do quote unquote loans between friends and family. Just structure it as a gift. And then if you decide later, with a good conscience to repay the gift, that's your decision. USCIS, do that outside the EB-5. But, anything between friends and family, in my opinion, should be structured as an irrevocable gift to, better portray it to USCIS.
And just to add to Brandon, I think regardless of whether you do a gift or a loan between friends and families, pick a friend or family member that's going to be okay disclosing their financial information,
Right.
because they're the ones you are going to have to do a complete source of funds analysis, or where they got the funds that they are loaning or gifting to you. We have run into issues where people have taken gifts and now that friend doesn't want to provide their tax returns, doesn't want to provide their W-2 income statements or bank statements, and it causes some real issues. So pick a good friend first.
Yeah, I'm more inclined to, I also bring this issue up, and I'm inclined to try, if possible, to have a conversation with that friend or relative who's basically gifting the money, to tell them, look, once you jump into the swimming pool, you're going to finish the race. You're not going to just back out on my client when there's an RFE and say, I've given you what you needed, now you're on your own. Or even worse, and I think we've all seen that. Brothers may have given each other a gift, and now they're suing each other in criminal court. They're not even talking to each other. Forget about documentation. You'd be lucky if they don't go out and malign you on the other side. So there's just a whole bunch of issues. And what Brandon and Niral and I see on a regular basis does make us worry about these gifts from friends and family.
I will say this, that obviously it is okay to take a loan. Yes, not recommended. We recently had like 3 or 4 approvals, and I know these are like family, friends, and extended family that did it through a loan from another friend or family. One thing to remember is that there is an IRS prescribed interest rate that needs to be charged. It cannot be an interest-free loan. So when you're taking a loan from someone within the United States, it should not be an interest-free loan. That is something to remember, and that adds to the legitimacy of the loan as well. And obviously, the source of funds have to be properly documented for the loan, and there needs to be a repayment period. Like, you need to be on the hook for it. So you have to meet these requirements. Again, if you can avoid it, great. If not, there are ways to go about it and get an approval. The next hot topic I want to touch upon, or subtopic, is regional center loans. Now, a lot of regional centers, through their affiliates, have been giving out loans to investors that invest in the regional center project. So all three of you, if you have experienced it, what has been your experience with regional center loans?
I think, generally the experience has been good. I mean, of course, we have seen some RFEs and we've seen some adverse decisions here and there. And I think it's a little targeted. And, we're of the viewpoint that, what's it to USCIS? If you've made unsecured loans permissible, and as long as this loan is structured correctly, as long as there's an underwriting process where you're checking the credit worthiness of an investor, the financial ability to repay that loan, there are interest payments which are being sourced lawfully by the investor, and the funds can also be sourced by whoever the lender is, then what's it to USCIS? I mean, you're clearly meeting all the requirements. Just because they think it's a little unorthodox and it's not something they traditionally see, that doesn't necessarily mean that this isn't approvable. And, we've seen plenty of approvals through regional centers who have used the loan program.
Got it. Brandon, what's been your sorry.
No. Go ahead, Brandon. Go ahead.
Our experience to date with it has been positive, but I think what USCIS is looking at, and unfortunately, I'll cite a group that has a loan program overseas, and like they're running their loan program, whatever. I'll skip the details, but basically they were blatantly advertising out there, EB-5 for $100,000, participate in our loan program. And so that's the concern of USCI. This goes back to the 90s, 1998, matter of Shung, one of the four precedent decisions at EB-5, where these groups would have loan programs and they'd have these kind of ethereal balloon payments at the end. And so it was basically, EB-5 for $100,000. And therefore there was never, and in those days, 500,000 at risk. So you take number one, USCIS generally not liking loans because they lost in court over it. And number two, their kind of longstanding concern of, to use Rohit's phrase, marginal groups, structuring loan programs as a way to entice investors at less than the required at-risk amount. Yeah, I mean, as long as the loan programs are structured properly, then USCIS might ask questions, but they should be approved on a routine basis thereafter.
Picking up on what Brandon said, if you went back to the early 90s when the program just started, I think a lot of the reason why the program did not succeed in the beginning was exactly these kind of loans where the immigration and the courts felt that the investor was not investing any of their money. There was nothing that they had put at risk out there. It was all somebody else's money. And I think that raised a whole bunch of issues which might come back again to haunt us with these loans. We just don't know. And I always encourage the investors to read the terms of the loan and the terms of the loan repayment very carefully and understand them. It's not just enough to say, oh, the regional through their affiliate or through an outside source is giving me, a loan of $400,000. But then have you realized that maybe at the start of the year, you got to pay them the entire interest amount, which could be a very large amount of money. And you may not have the ability to do that because you've stretched yourself so thin by taking the loan that could become an issue. So some of these investors, I'm not saying I do that intentionally, but I just caution them, put a little bit of a break on their thought process, like just revisit what you're doing. It's your money. It's your green card. Of course you got to do it. And like Brandon said, and we all agree, it's probably the best option today for most people. But you got to just think about it and take a little bit of a step back a bit.
Yeah, there is no such thing. There is no such thing as a program where you can only invest half the amount and that's it.
Yeah.
Again, this is still an $800,000 minimum investment, and your loan should be structured in a way that still holds true. And it comes back to your point, Abhi. Then again, you have these interest payments. This needs to be an actual loan that you would otherwise get if you were to go to like a bank or another lender like that.
Right.
I have seen a loan structured and an approval where the principal was not starting to be repaid for X number of years. Maybe it was psychologically or intentionally planned with the return of the principal coming in, but they were making interest payments all the way through. And we did get a approval, no RFE, nothing, straight out.
That's the big differentiator there, as long as they're making ongoing interest. Yeah.
Yes.
Right.
Yes.
So that's how I feel it should be structured anyway, right? So the first thing is I want to clarify, just from a regional center perspective, or I guess from a Golden Gate Global perspective, we just have the loan product to enable investors. We ourselves don't encourage it. It is just that we come across a lot of H-1B investors and they have 500K or 600K available now. They have visibility on getting those funds in the next year or so. And we just want to assist them with that. Is loan our primary product? No, we don't promote. We are not a lending institution promoting loans, right? So it's just an enabling thing. The second thing is what I feel makes it more palatable for USCIS is that the loan is not for the entire duration of EB-5 investment. If you are on the hook to repay the loan in 2 years or 3 years, whereas the loan term for EB-5 is 5, then I would say the presumption is in your favor that you are on the hook to repay the loan. It is not dependent on repayment of the EB-5 funds. I think that's a very important aspect of regional center affiliate loans. Because if you have a loan term of 5 years, which overlaps with an EB-5 repayment timeline, and you're repaying the loan from the repayment of your EB-5 funds, then it can be held against you that you never invested the full amount. So there are ways of structuring the loan, getting approvals. We have, I think, more than 10 or 12 approvals in the last 1 year with the loans. And of course, there are RFEs. And as an investor, RFEs and NOIDs are very serious terms. But someone who's been on the legal side, and all of you are lawyers, this is like an everyday thing. It happens. It is just a request for evidence because there is no hearing, right? This is all like behind the scenes. USCIS sends you a notice just to tell them more about the loan product or the project, etc. So again, your thoughts on how are RFEs and NOIDs different from each other?
I mean, I think actually, and all of us, we work in other immigration categories, not just EB-5. And I think I speak for all of us when I say that an EB-5 RFE is considerably easier than something we might see under the EB-1 category or EB-2 or EB-3, because it's so much less legal interpretation. It's really 90 to 100% factual based. Right. They're asking for bank statements. They're asking for these specific numbers. Where did this particular source come from, and how did it get there? And the difference between RFE and NOID is essentially they're the same, right? They're both requests for evidences. One is a NOID where you have 30 days or 33 days to respond. An RFE, they give you the 90 days. That's really sort of the main difference. But both of them are just requests for additional evidence or clarification on whatever was already filed.
Right. I mean, if you were a litigator, this would be a hearing and a second hearing and just addressing the judge's queries, right? Except we don't have that here, so we just receive notices. Well, the next topic is timelines for adjudication. And again, it's all over the place. But let's start with Rohit. What's been your experience, rural versus higher employment, and then Neeral, you, and then Brandon. So Rohit, what's been your experience?
With rural, it's been great. I've been seeing approvals in 6 months and under. High unemployment, I'm seeing them dragging comparatively. So I haven't seen one in about 18 months on high unemployment. The rurals have been very good, but then the AOS gets stuck. So so we're kind of back to square one with saying, you've got the petition approved. Now somebody needs to pick up the AOS. And I try to explain to them that, look, please understand the difference is that it's the IPO office sitting out of DC that's adjudicating your 526. Your AOS is now being adjudicated by the immigration office, which is a different office. And then very often you're going to receive these transfer notices, which says for better efficiency, which I think is humbug, greater efficiency, we're transferring you to the California Service Center. Oh, welcome to the worst service center in the world out there. It's like saying you're going to the Chennai consulate for an interview. So I think clients need to understand. And I think something that Neeral said earlier and Brandon has said, and we all agree, just managing the client's expectations is such a huge part of the work that we do besides the substantive part. So I've been seeing good adjudication results on the rural projects.
Yeah, I would say generally USCIS has done better than before in terms of adjudications. I think right now, it's also important for everyone to understand your APEAD isn't based on rural or high employment. On average, we're seeing those probably issue within 4 to 6 months, regardless of which category you go into. In the rural, the I-526Es, we are seeing less than 12 months in a lot of these cases, which is really, really impressive. And I think high employment, usually around 16, and it can stretch to 24 months. And maybe later we can discuss ways to help with that, but that's typically what we're seeing.
Got it. Brandon?
Yeah, 2 points. So, data, there's several of the EB-5 trade groups periodically, well, I guess pretty much on an ongoing basis, keep suing USCIS to release filing data, and we represent one of these groups in that. We have one of these suits pending. But every time one of the suits is resolved and the data comes back, it's pretty much consistently the same, which is on average, the processing time difference between a rural 526 and a high unemployment 526 is 4 months. Now, EB-5 is, Neeral alluded to this a little bit at the end. EB-5 is one of the few immigration processes where you actually can have some control over your timeline. H-1B, L-1, EB-2 labor certifications, you don't. It takes the length of time it takes. EB-5, because it's your petition and not a company's petition, if you're tired of waiting, you can sue them through the so-called writ of mandamus process. And so we've gotten to the point here that we tell people, once you hit 12 months, whether, it's rural or high unemployment and you're tired of waiting, which you will be and you should be, then exercise your rights to force USCIS to approve these cases. Like, there's no reason in a non-backlog situation why you should be waiting 18 months or more, because you don't have to. I mean, I get EB-5 is expensive, and now you have to put some extra money to actually force someone at the government to get out of their chair and work on your file. But the answer is yes. And, the marginal cost of doing a writ of mandamus versus waiting another 12 months is de minimis, in my opinion. So you're in control of your EB-5 process. If you want to sue them after 6 months, personally, I think that's a little aggressive. But some do, and I think the results have been successful. And you can do that, or wait or you can just wait until the process naturally unfolds on its own accord. But you're in control of your EB-5 process. If you don't want to wait, take action.
Yeah. I have some follow-up questions about the writ of mandamus, but before that, I'd just like to share that I agree. Rural projects are so much faster than high unemployment, and Rohit's timeline is on point, at least with our projects, that it takes about 16 to 18 months to get a high unemployment approval and about 6 to 8 months to get a rural approval. Obviously, there are outliers. But something that really shocked us just last week is that our high unemployment project in California, the investor got an approval in four and a half months before they got their EAD and AP. And the investor sent us a screenshot of case approved and was like, what does this mean? Am I getting my EAD? And I was like, no, you're getting your green card.
Yeah.
So,
and of course, USCIS will keep the filing fees for the EAD and advanced parole. Don't even try to get those back.
Oh, yeah, absolutely. The same thing happened with one of my cousins in California. They filed this year in January. And on August 28th, they had their green card in their hand with a rural project. Had not heard, and just a month ago before that, they had heard on their EAD and AP. So the EAD and AP were delayed, and the green card was issued by August. Like that was the quickest I have seen, and it's just bizarre. But
That's
also goes back
fantastic.
to the point that cannot predict retrogression. Like if tomorrow retrogression hits and says it's 2024, I can give you examples of my own cousin who filed in 25 and has a green card. So anyway.
I have a funny example, but I'm going to save that for the end as a finishing touch. But go ahead. Yeah.
Okay. Now let's talk about a very sensitive topic, that is children aging out and the Child Status Protection Act. And Rohit, let's start with you. What is CSPA? How does it work?
There's no way to say it at a simple level, but at the simplest level, the law is intended to protect children who are otherwise going to age out, meaning turn over 21 when they get, when they're ready to get their green card. In its simplest form, for people to understand, the age of the child freezes when the petition is filed. Mm-hmm. It remains frozen, not the biological age, the immigration age, or the make-believe age, whatever you want to call it, remains frozen as long as the petition is pending with the Immigration Service. So if my son was 22 when the petition was under 21, when the petition was filed, and is now 22 when the petition is approved, if the petition was pending for 2 years, I get to take off the 2 years from my 22 and the child would still be under 21. If the petition is approved in 7 months, my child is going to age out because he's going to be over 21 when the petition was approved, even after deducting the time that it was pending at the Immigration Service. You now get into complicated issues of what is the age, or how is the age of the child going to be calculated at the consulate and for consular processing, and that may be beyond the scope of this entire conversation. But that complicates life. I've had wrong decisions made at the consulates, which we have got overturned in Washington, D.C., but it has still, unfortunately, hurt the individual because of the timing and the retrogression and stuff like that. But you got to be careful about that. They have now also passed internal guidance, which kind of offsets a good guidance that they had passed earlier and says you now have to use the final action dates, which according to people who are familiar with the visa bulletin that's the date when you potentially can be issued the green card because the visa numbers are available. You got to use that date for calculating whether the child is aged out or not. Earlier on, they had passed an internal guideline which said you could use the filing dates, not the final action dates.
Right.
And then there's, of course, the tension between what is being followed at the U.S. consulate by the State Department and what is being followed by the Immigration Service. So this is a very sensitive subject, which you're absolutely right about that. You must discuss that carefully with your attorney. And even there will be, according to me, there will be points in time where the attorney can give you a best judgment call or a best guess, but you're going to have to wait to see how it eventually plays out because of all the variables that we've talked about through this entire wonderful seminar. And I'm really hoping people are getting a lot out of it because you brought up some fantastic issues.
Yeah,
Thanks for that. Neeral and Brandon, I'll just come to you. But before we proceed with this topic, I did not give background to our attendees. So qualifying dependents for an EB-5 petition are spouse and unmarried children below the age of 21. That's why the age of 21 was mentioned. It is a very important age. And for immigrant visas, if your child is already over the age of 21, they do not qualify with parents. In that case, you will have to file their petition separately. But if they are under the age of 21, they will qualify with their parents, provided the date, the priority date is current. If it is not, then obviously Child Status Protection Act comes into play. And even when it's current, it comes into play because we want to lock their age in under 21. Now, this, as Rohit mentioned, it's different for consular processing and adjustment of status. And different attorneys have different views on it. So I want to specifically also talk about when, for adjustment of status, does the age remain frozen for longer, even if there is retrogression, versus consular processing where you've not filed adjustment of status. So, for example, if my child is 19 years old and India is retrogressed by 3 years, what is the difference between filing under consular processing versus adjustment of status? That's the question. So I'll come to Neeral.
Okay, go ahead.
Yeah, I was going to say, I think, and this is where there's the differing perspectives. It's when it comes to the adjustment of status. I think the conservative view is that, okay, your age locks at I-526E filing, and then it unlocks at I-526E approval. If you're retrogressed, then the age starts to clock right away until a visa becomes available again, i.e. the 485 does not necessarily lock in the age. I don't recall the exact provisions in the policy manual, but it's a little bit contradictory where in one place it suggests that because you're filing the adjustment when a visa is available, that should lock in the age. But, I think it's also one of those things we're not going to know until an child actually ages out relying on that provision, and then B, it may have to be litigated. But I think the conservative measure is just the age locks at 526E filing only.
Got it. Brandon, what are your views?
Yeah, and so my opinion on the matter is that the Child Status Protection Act has a quote in there about seeking to acquire permanent residence. So in my opinion, there's no higher form of seeking to acquire permanent residence for someone in the United States than filing an adjustment of status, which you can only do if there's a visa, right. Well, at least under Chart A, if final action date, if the visa is available at that time. So, but yeah, I mean, this recent guidance that came out, it throws a little bit of, so it's almost kind of like, Oasis' first album. It's going to be a definitely maybe when the time comes. But, strategically, I think we're back to a situation where, pre-RIA, where we didn't have concurrent filing, the advice most of us gave was, okay, if the child is 18 years of age or older, it's probably worth considering having that child be a principal applicant. I think, we might be back to those days as well. So if definitely, it's one of those things like you don't want to find out the hard way. So if child is 19 or 20, even with concurrent filing, like, I don't know, like it may not be worth it. And that it might just be, depending on the the family dynamics and who ultimately wants to benefit from EB-5 and how much funds there are to do it. That might be a situation where you do two EB-5s just because you don't want to find out, and adversely in the future that, oh, the policy's changed again, and now and it's changed in the negative.
Right.
These are all things that deserve consideration.
And
Yeah,
we've also consulted on. Oh, sorry, carry on, Roy.
No, go ahead, Nero. Go ahead.
I was going to say we've consulted, in that exact situation. We've had clients come to us and we've sort of walked them through both interpretations of CESPA. And, I do believe that there's room for litigation if they were to come out otherwise. And so, we do have some clients who are okay going down that road.
Yeah, I think this latest interpretation or guidance from the immigration has kind of definitely thrown a spanner in the conservative understanding that once you filed your AOS, and you could only file it when the visa numbers were available, you were fine. Your age was frozen. You didn't need to worry about it. Now they've kind of talked about it a little differently, and I'm also inclined to agree with Brandon and Nirel that you're probably going to see litigation on this issue, because I don't know who all and how many people it's going to impact. So this is a bit of a moving target.
Yeah, and tactical use of writ of mandamus in these situations, absolutely critical.
Yeah.
I mean, I also advise parents to be patient in terms of file the petition in your child's name. Your child's anyways going to be over 21. 5 years later, from the receipt of a conditional green card, they become citizens and they can sponsor you. So yes, it's asking a lot in terms of patience. It's like a 7-year wait. It's still shorter than the 40, 50-year EB2, EB3 wait, but it's asking a lot for a parent to just invest in the child's name. But here's the thing. That is the only way to keep the family together. If you have money to just file one petition, you're better off filing that petition for your child, and your child is anyways safe, no F1 visa required, no H1B required, they'll be here, and then they can sponsor you when they turn, they're already 21 and they become citizens. So, and that is free. So if parents are willing to do that versus take a risk and find out 2 or 3 years later that that child doesn't qualify with them, I think that's worse.
Yeah, but it also complicates life when you've got more than one child.
Right.
And the second child, the third child certainly qualifies. That's the reason why I think Brandon also said we all agree that it's so important to understand the family dynamics and who really needs, not just wants, but who really needs that EB-5 as a priority.
Yeah, we've seen this change a lot with, the particularly markets in China and Vietnam, where pre-RIA, there was this kind of feeling that the whole family had to participate in EB-5, even though the whole family didn't really want to or need to. And now when you have concurrent filing and then some parents are in the home country and the child studying in the US, they say, okay, well, it doesn't make sense anymore, which is something that, getting back to like the previous demand, lowers the kind of, demand for visas overall. That, in the past, like one petition for out of Vietnam was like 6 or 7 visas. Now it's like maybe 1 or 2 or 3. And so, yeah, these all come into play. But yeah, unfortunately, it's something we have to start thinking about again.
And continuing on to issues related to the H-1B visa community, a lot of H-1B investors, their common sources of funds are RSUs or employment income, maybe home equity line of credit, but also self-directed IRA. So Nirel, I'll start with you. Can you shed some light on what is self-directed IRA? Is it kosher to use it as source of funds for your EB-5 investment, and how does it work?
Yeah, sure. And then the short answer is yes, it's allowed, and we've had many cases approved of people who have used a self-directed IRA. A few caveats to it is that it has to be, a previous 401k that you roll over into a self-directed IRA. And we've had some attorneys out there who say otherwise, but our belief is that only the principal applicant can roll over their self-directed IRA just because you can't have two people subscribe to a project. But that has become a very common source, especially for people who have been in the H-1B community, who have been here for 10 plus years, moved around jobs, and they have these previous 401ks that they can now roll over without taking penalties.
Thanks for that. Brandon, your thoughts on this?
Yeah, and I concur with Nero. Nothing to add to that.
Rohit, anything?
Yeah, nothing to add. I actually haven't had much experience with it. There was a regional center that I was working with, which toyed with the idea of, and the reason why I say toyed with the idea was they eventually decided not to go ahead with it, but they did consider this as an option that they would offer their investors. It seems as if, again, based on what Neeraj said as well, that it is usable, but the jury seems to be out on it a little bit in terms of the long term.
Yeah, so there's proof of concept. We've had 100% success rate with self-directed IRAs. A lot of our H-1B investors have used it along with their RSUs, etc. And again, with that also comes the question of partial investment. RSUs, right, not vested, will vest in three months. They want to lock in their priority date. So both partial investments and self-directed IRAs have worked, and so have regional center loans. So last couple of questions, gents. Thanks for your patience. If someone on an F1 visa files an EB-5 petition along with concurrent AOS, advanced parole, etc., when can they travel outside the United States? Rohit, I'll come to you for that.
Sure. If they're on an F1,
yes.
Super important to remember, you cannot under any circumstances leave after you've applied for an advanced parole without the advanced parole in your hand. Make sure that advanced parole has your photograph and your name on it. And I don't mean it as in jest, because we've seen different people's photographs and different genders than the person who's supposed to get it. And it's a headache to try and get it remedied. And that's why I see Brandon and Neeraj smiling. We've all, well, I can't do that, but they've certainly tried to tear their hair out in frustration. But the bottom line is that's super important. If you leave without getting the advanced parole, you have automatically abandoned your adjustment of status. And then if you come back using an F1, you've got other issues to deal with as well. Just had a long conversation with a client yesterday where they want the child to attend back home for a religious function, and come what may, they've said, we will abandon the adjustment of status and let the child come back on an F1. And I basically told them they're going to sign off a disclaimer and a waiver, understanding that they've been advised against doing it and they could end up complicating his life. The only advantage in that case is he's not born in India. So he might fall under the rest of the world quota and comes back on an F1 and then files a new AOS. But absolute no to do it. Please follow your attorney's guidance when you filed your adjustment of status. Of course, your attorney will also discuss what you need to comply with before you file the adjustment of status. And I think that's the subject of many a discussion and many a difference of opinion. But certainly after you filed your adjustment of status, if you're on an F1, do not leave. If you're on an H or an L, and I think that issue comes up, you have a dual intent, but you have to understand that while you do not abandon your adjustment of status, the immigration will almost 100% deny your advance parole, which means you're going to come back, file all over again, and play that game again.
I can't stress enough how much people should contact their attorney when they think about a vacation. I mean, I recently had a client who left the country in F1 while the adjustment was pending because his cousin said it was okay to do so. And I'm like, this is absolutely insane.
His cousin said that?
His cousin said, yeah, it's okay for you to travel. And I found out afterwards when he was abroad that he had done so. And so your first point of contact, whenever you're thinking about a vacation, doesn't matter what status you're in, even if you're an APEAD and you can travel, always contact your attorney first.
Yeah. And I should stress, it's not just F1s that have this advanced parole and on the return 90-day issue, it's TNs, it's E1s, it's E2s, O1s as well. Basically, every B1, B2. Basically, it's everyone with the exception of H1B and H1B, H4, L1A, L1B, L2 individuals have this issue. And yeah, I just dealt with it too. I had someone on an E2 didn't even tell me. They just went and traveled, even though I told them not to. And guess what? When the notice of intent to deny for the 485 showed up in our office, and like, oh yeah, here's all here's all the times your client like left and re-entered on an E2, and there's no way to cure it. There's no way to cure it except to refile, which that isn't pay all the filing fees again. But then knowing that USCIS could be like, wait a minute, your person entered on F1 or TN after they filed EB-5 and file adjustment, and try to hit them with retroactive entry fraud. It's just
yeah.
And you've also possibly now got slammed with the possibility of unauthorized employment.
Yeah, that's true as well. Yes,
you just complicated life in so many different ways that it was not worth listening to your cousin. Definitely not.
Your cousin's great, but yeah, call Nero before you call your cousin next time.
How is it different for Brandon? This is to you. How is it different for H1B and L1A visa holders when they file for adjustment of status, etc.? Can they travel overseas without abandoning it?
That's correct. Well, they'll probably have their advanced parole denied for abandonment if they travel while it's pending. The adjustment of status will remain, and what differentiates it is H1Bs, H's and L's have what's known as dual intent, i.e., they can be on a temporary non-immigrant work visa, yet still pursue permanent residence without violating the terms and conditions of their underlying non-immigrant visa. H's and L's are the only visa categories that have explicit dual intent. So yeah, so someone on an H or an L can file for EB-5 adjustment of status, leave the U.S., not be considered to have abandoned the adjustment of status, and re-enter under a valid H or L visa, no problem. However, now that we have, I used to tell H-1Bs, the advanced parole, it's a waste of money, $630, and it takes, 6, 8, 9, 12 months. So if you travel after 5 months, you abandon, have to refile. So maybe save the money and don't do it. You can always file later. However, now with the Trump administration stunt from last week, now I've kind of changed that to say, first of all, don't travel on your H if you don't have to. And let me stress, don't travel on your H if you don't have to. But now spend the $630 per person and get the advanced parole and try to wait until that's approved before you depart the United States.
So I guess the difference is if you are on a non-immigrant visa without a dual intent, such as B1, B2 travel visa or a student visa, you leave the country without advanced parole, also known as travel document. You abandon your entire adjustment of status process.
That is correct.
Whereas if you're on H1 or L1 dual intent visas, you don't abandon your adjustment of status, only your travel document.
That is correct.
That's an important differentiator. With that, I would also like to ask you about the 90-day cool-off requirement, the difference between, again, dual intent and F1 or visitor visa. Is there a difference, or the cool-off period applies to both? And what is a cool-off period like? Yeah. I guess, Nero, if you...
Oh, go ahead, Nero.
Yeah, so I think, as we've talked about, you can have a dual intent visa like the H or L, where you can have the non-immigrant intent to temporarily work in the US and the dual intent to pursue an immigrant visa. There you can enter on an H-1B, and the next day you can apply for an immigrant visa, like an adjustment of status, not a problem. With these other visas, the Bs, the Fs, the Es, basically anything outside the H or L, those aren't dual intent. So first of all, you can't come into the US for the sole purpose of applying for a green card. But, of course, intent can obviously change depending on what you're here to do, what your future plans are, et cetera, et cetera. Now, if you fall within 90 days, and I think the FAM is actually 60 days, but I think it's 90 days, a little bit more the conservative view. If you fall within that time, USCIS can come back to you and ask you to prove that you had the appropriate intent when you entered the US on your non-immigrant visa. Show us that you came in on that visa and that you were complying with the activities outlined by that particular visa and that you didn't have an immigrant intent. After 90 days, you're not really running into that sort of issue.
Got it. Rohit, Brandon, do you have any thoughts on this topic?
No, I just think, my gut is that it's better to take the safer option. As opposed to having to worry about explaining your intent, which can be questioned several years after you had the intent change, and now convince an immigration officer that that was my true intent when I came in. It's going to depend so much on facts and circumstances. And I'll give you a simple example where it can really come back to bite you. Let's say the family comes in and they've come in husband, wife, and young kids. Within 15 days, they've come in at the end of August. And you know what? Middle of September, school started. The kids were enrolled in school. Now you're going to try and convince an immigration officer 90 days later that you had no intent but to just come and travel the U.S. and be a visitor. That's going to be a real stretch. None of us over here would be inclined to buy it. And I don't see an immigration officer who is now charged with probably more deportation than favorable adjudication is going to give you the benefit of doubt. So maybe it was an extreme example, but I don't think it's unheard of, and I don't think it's that rare either. So you need to be really careful and, again, consult with your attorney, talk to them about it, make sure that you can be protected in the future, and then file the application.
Got it. And the final topic, the least controversial topic of this webinar. What are your guys' thoughts on the gold card?
What? Which gold card? What gold card? Yeah. What are you talking about?
Is it a law? Can you, or not us, but can people buy this gold card? What's going on?
Okay. Yeah, this first came about in February, and they announced a gold card, and they said we'll have it online in 2 weeks. There's not going to be any more EB-5. Fast forward 8 months later, we still don't have a gold card and we still have EB-5. Obviously, we saw the recent changes, and I say that loosely because there are changes, but there's still no process, there's no form, there's no regulation. No one knows exactly how to do any of this. All they did was change some numbers around and introduce 3 different categories of colors. But that's about it. Still to this day, there's nothing of substance is there.
The program doesn't exist. Which program exists? It's just an EO. It's just some kind of executive order, which doesn't exist. And I believe there's a cabinet member who's basically said that there's a line of 1,000 people waiting for it. I don't know which 1,000 people there are. I don't know how he defines 1,000 and how he defines people. But I'm kind of very skeptical. Apart from the fact if it does, it's not replacing the EB-5 in my opinion. Maybe it's a program that runs parallel and has different qualifiers, different qualifications. Maybe it's offered to a different audience. And I think it's really important to remember the difference. It's a donation. You're never getting that money back. I think that's really important to remember. And it's a donation per person. So there are no derivatives, no dependents, no family members getting it. Okay, I think I've ranted enough. Brandon, your turn.
Yeah, I was going to dignify it with more seriousness than it otherwise deserves. So what I mean by that is yeah, you were just leading into that part, Rohit. Yeah. Even if it becomes real as it's stated on paper, it's a far, far inferior products. It's a donation. Derivatives don't count. People out there in certain markets have convinced themselves, oh, great, I can do this if, I have problems proving source of funds. Well, no, if you read some of the comments, they're using their extreme vetting nonsense language again. So no, it's not a way to evade, standard EB-5 source of funds requirements. And then, oh, by the way, it's even if they give, super fast processing on the 526E equivalent of your gold card application, well, they're going to apply visas to the existing EB-1 and EB-2 categories, which, as most of you already know, is basically doesn't move and takes forever. So even if it becomes real, the way it looks like it was put on paper last week, it's still a far inferior product. Gets you less for more than the existing EB-5 does.
So I have two questions as a follow-up. Sorry, Avi, don't mean to take your pride of place here, but question. One, they talk about the tax code where they say you won't be taxed on any non-US income after you're spending. I think that's for the platinum card. Doesn't the tax code need to be changed? I mean, how is that going to work? I mean, I think that's got to be also put into play, right? And then you're also talking about giving all these cards. Where's the process? How do we know what form to fill out? And if you're taking numbers out of EB1 and EB2, how do you take away numbers from numbers that don't exist? There's a retrogression. There's a backlog. Where are you getting the numbers from?
Yeah.
Well,
Okay,
I know where
I'd
to
love
apply
to hear
for
your
it.
guys' answers. Sorry.
I know where to apply for a gold card and a platinum card. You go on the American Express website, you get it.
And there they don't care about your source of funds.
Exactly.
And there's no extreme vetting. Yeah.
As parting notes, gentlemen, thank you so much for joining us. Thank you so much for giving us more than 2 hours on a Saturday. Neeral, especially you. I mean, you are in India right now meeting clients, and it's late for you, but thanks a lot for that.
I have a sunny day outside in New Jersey that I've spent 2 hours with you guys. Yeah. But it's been a pleasure. Thank you so much, Abhi, for the invite. And of course, Brandon,
Thank you, everyone.
always a pleasure.
Thank you, guys. It was a pleasure.
And thank you, attendees. And if you have any questions, I've shared our info@3gfund.com email ID and our website. If you want to be connected with Neeral, Brandon, or Rohit, let us know. Happy to do that. Or you can just Google them and you'll find their email IDs. Thank you, panelists. Thank you, attendees. And look forward to addressing more queries along the way.